All right, let's bring in our think tank tonight. We've got a great one. We've got both sides of the coin here with us tonight. We've got Dave Arenberg, State Attorney down in Palm Beach County. Great to see you, Dave. Kimberly Bandeau, criminal defense attorney, former prosecutor in Georgia where this has taken place, and Lawrence Zimmerman, criminal defense attorney, actually president of the defense bar in Georgia. Correct, Lawrence?
Georgia Association of Criminal Defense Lawyers. Yes, Vinny. Thank you.
You got it. All right. So I'm bringing in the heavy hitters tonight. Dave Arenberg, I'm going to start with you, State Attorney, Palm Beach County. Can people get arrested and charged without a case being presented to the grand jury?
Yes, Vinny. But when it comes to very serious crimes, a lot of DAs will send those cases to a grand jury first. Now, I don't know the practice in this particular jurisdiction, but it may be that in a case of this kind, they would normally take it to a grand jury, which could explain why it's going there. Another reason why a DA may send it to a grand jury is to vet the case. You get the opportunity to go before 21 random individuals who can then ask questions, and you can strengthen your ultimate case. Taking cases to a grand jury could ultimately give prosecutors a better shot at a guilty verdict. You don't want to rush these things because once you start making an arrest, the clock starts moving, and you better get your ducks in the row soon. And another reason why the district attorney may want to send it to a grand jury is if there is a question of whether they should charge manslaughter or second-degree murder, and so they may seek guidance before the grand jury. So what I'm saying is that the fact that they're taking it to a grand jury, in my opinion, should not be read as any nefarious motivations here. This could be just the standard practice or strategy involved.
No, the other problem is we're in the middle of this COVID shutdown and they can't get a grand jury until June. Right. Kimberly Bandeau, from your perspective, I mean, couldn't we arrest this guy and the case could proceed like other times when you catch someone who shoots and kills someone?
Yeah, listen, so I worked as a magistrate judge here in Georgia. Do you know how many times in phone calls I got in the middle of the night to sign murder warrants and every other kind of warrant? You can get a warrant from a magistrate, you can present it, have a preliminary hearing, and then you take it forward to the grand jury. You do not have to wait until June. You can get one now. I guarantee you there's a magistrate on duty in Brunswick, Georgia.
Lawrence Zimmerman, I'm looking at this case and I'm wondering, what evidence beyond this video, what do we need to find out that isn't in the video, right? Everyone says the investigation, we got to find out, I mean, beyond the video, what evidence do we need here?
Well, it's a tough case for me. I have to reconcile two things in my mind because I believe in civil rights and the fight, and I believe there's racial inequality in this country. I'm also a criminal defense lawyer. I also believe in presumption of innocence. And so I'll give these two men the presumption of innocence, but based on the video alone, it looks pretty bad. If he's just jogging, well, let me back up. Even if, and I printed Georgia case law I can read off to everybody, even if he went into a house that was a construction site, at most it's maybe a criminal trespass. Even if it was a burglary and he has left, it doesn't justify these people stopping him and murdering him. You can't be the primary aggressor and someone react to you and then you shoot the person. That's still murder. That's not justification in Georgia. And let me add one more thing. The reason I believe that they didn't arrest these two men is because it's political. Nobody wants to have the courage to make the decision. They rather have, in Georgia, 16 to 23 grand jurors listen to the evidence, and then if there's an indictment, it doesn't reflect back on the district attorney because this is a former investigator at the DA's office. It reflects on the people of Glynn County instead. I personally feel that's just a way to deflect. Maybe I'm wrong, but in most 99% of cases, it's not a police-involved shooting. The Georgia Bureau of Investigation isn't coming in to investigate a cop. This is a video that there's a shooting, and it's clear there's probable cause, in my opinion. There should have been an arrest made.
Yeah, they're not police officers, and I think there's a law against pointing a gun at strangers. I don't know. I might be wrong here, Kimberly. In Georgia, can you go out in the street, get on the back of your truck and point a gun at someone?
No, you cannot. It is a crime.
There's the probable cause right there. All right, Dave Ehrenberg, what do you want to know as a prosecutor investigating? What do you need to find out beyond this video?
Ultimately, you want to do justice here. You want to do justice for the victim. So we want to make sure that the case is pretty airtight. So let's find out what happened before the camera started rolling. What happened when the camera was not on the second shot? What was going on there? So you want to interview all the witnesses. And one thing that jurors hate is when these witnesses or the defendant lies. And if you can show that the defendant gave a statement to the law enforcement officials, and then the jurors can look at the contradiction with their own eyes because of the videotape, then it exposes defendant, and jurors will be much more likely to find that defendant guilty. So if you can show contradictions between the statements given to investigators beforehand and the video, because remember, these guys didn't know they were being recorded. So if you can show that contradiction, that goes a long way in the jurors' minds.
All right, we have a long way to go on this story. We're going to talk about it some more later in the hour, get your reaction on social media. But when we come back, a case involving an actual police officer. This one's in Tennessee. This one is getting ready for trial. I mean, as soon as the shutdown is over, this case is going. It's a case that, again, is caught on camera. It's going to be graphic. I'm warning you now.
Body.
But the bottom line is this. Any person in Davidson County who shoots someone who is running away from them, shoots them in the back and kills them, needs to be held accountable.
And that's the issue in a trial we're tracking here on CourtTV. That'll happen as soon as the shutdown is over. This trial will happen in Tennessee. Andrew Delkey, police officer, pursuing a suspect, believes there's a gun. A gun was found in the area. Shoots the victim in the back. Surveillance videos everywhere. Graphic warning now. Julie Grant has the story.
Officer Andrew Delkey and Daniel Hambrick crossed paths for the first time on July 26, 2018. But only one of these men would walk away alive. The fatal encounter began on the streets of North Nashville. Officer Delkey was on patrol, searching for a stolen vehicle. At some point, while Hambrick pulled inside an apartment complex and took off, allegedly armed with a gun, surveillance video shows the men, both 25 years old at the time, in a full sprint. They round a corner, and then you see Officer Delkey stop, plant his feet, and fire at Hambrick as he runs away. Hambrick falls and never gets back up. According to reports, Hambrick was hit 3 times, twice in the back and once in the back of the head.
And I need judgment either. That's not my role.
City officials forced to respond as community outcry intensified.
My role is to make sure that on the front end, we are doing the absolute best we can as a community when it comes to policing.
The district attorney releasing video of the shooting, hoping its bid to be transparent will build trust with the Black community.
The police officer fired 4 times. 3 of those bullets ripped Daniel apart.
But the move is a little solace for Hambrick's grieving family.
My daughter is now thinking that the police is the enemy.
According to a warrant, Officer Delkey said he saw Hambrick holding a gun and that Hambrick didn't comply with verbal commands. Despite his claims, prosecutors filed charges shortly after the release of the video. Hambrick's family faced Delkey during a pretrial hearing. Defense attorneys suggesting Delkey was simply following police practice from the moment he squared his feet and pulled the trigger.
He's doing what he's taught to do, that this is the most serious thing the police do, and if they have to use deadly force, they want to hit what they're aiming at.
But the prosecution countered, questioning the witness about Delkey's decision to use deadly force.
You're in agreement with me that that was his decision to make, and at that point, that was the decision that he made.
And I'm in agreement he made the decision because the subject had a gun in his hand and wouldn't follow directions to put it down and was possibly threatening people in the area and Officer Delkey.
The judge ruled the case should go to a grand jury.
Mr. Delkey, is there anything you want to say to the family?
And in January 2019, Officer Andrew Delkey was indicted for first-degree murder.
Her son is gone for no reason. No reason. He's gone because Officer Delkey.
The Fraternal Order of Police is standing by Delkey, saying the prosecution is politically motivated and could lead to officers second-guessing themselves in life or death situations.
Is it worth putting everything that we have on the line when we know that our city's not going to support us when we're right? And absolutely, I think the question is no, it's not.
The biggest question since the indictment is who should hear Delkey's case.
The hearts and minds of Davidson County residents have solidified into two intractable camps.
To support its motion to move the trial out of the county, the defense conducted polling that shows many residents have already made up their minds about the case. Results showing an even split between guilt and innocence.
The Davidson County jury is unlikely to provide the fair trial guaranteed to Officer Delkey by the Constitution.
A change of venue is not warranted because there are fair and impartial jurors in Davidson County, Tennessee.
The court agreed with the state, so the trial won't be moved. But Tennessee has postponed all jury trials until July due to COVID-19. For now, Officer Andrew Delkey remains decommissioned, free on bond, and facing the possibility of life behind bars if he's convicted.
And it seems the prosecution's case really is the video and how Officer Delkey stops while the victim is still running away from him. You know, other factors involved here. Let's bring back in our think tank. Another difficult one here. Different scenario, though. Here you have a police officer, and a police officer believes that the man he's pursuing has a weapon. Lawrence Zimmerman, I'm going to begin with you on this one. Another tough one for you.
Well, there's a little bit more to work with. I read in 2017, Officer Delkey did not use a firearm. He used a stun gun. He was admonished by his supervisors and told he had to use a firearm next time. So he has that as part of his history where he's reprimanded for not using a firearm, and then he believes this man has a firearm and he's chasing him. That could be a danger to other people. If this man was running with a firearm, he could potentially be justified as a police officer in the line of duty. There's a first shooting, my understanding, in the history of Nashville in the last 40 years of a police-involved shooting prosecution. You know, in the line of duty is different than just a citizen. You know, police are trained. They are allowed to shoot to kill if they believe there's a felony occurring and there's danger to other people. It's a much harder case for prosecution.
Kimberly Bandel, criminal defense attorney. You've been on the other side as well. You've been a magistrate judge. How do you see this one?
I think it's going to be difficult for the defense because he was literally running away, so he wasn't a danger as far as the officer being shot. And so I think he's going to have a hard time overcoming that as to why you would shoot someone in the back when they're running away from you. So they're not trying to confront you. They're running away because they're scared. And so that's going to be a problem, a huge problem.
But Finn, if he had a
Dave
gun in his
Arenberg.
hand, sorry.
Go ahead, Lawrence.
If he had a gun in his hand, if he legitimately had a gun in his hand, and that's the evidence, and he's running through the public with a gun through the streets, that's a danger to the community. I'm not justifying it morally, but you're asking me legally if it's justified, and it could be. It may not be first-degree murder, maybe manslaughter.
And I would disagree with that.
Dave
because
Arenberg,
it's not
jump in
illegal
here.
to have a gun.
Dave
Vinny, I
Arenberg,
think
let me jump in your thoughts.
Vinny, I think this is similar to the Walter Scott case. You remember that in 2015. You had an individual who's running away from the police, and he was shot in the back. And because of the video, that cop is now sitting in prison serving a 20-year sentence. I agree with Kimberly. The video speaks for itself. I actually think there's more evidence in this video than in the last video in the Arbery case, because in this video, you see everything. You see all the shots. In the other video, you missed the second shot. In this video, you see before, and you see the officer square up as the guy is running away. And juries hate it when cops shoot people in the back. I know that because I had a case very similar to that, and we got a conviction. So I think this is going to be a real uphill climb for the defense. I expect this officer to be found guilty, if not of murder, then at least of manslaughter.
But Walter Scott didn't
So,
have.
Kimberly
Walter
Bandel,
Scott
let me-
case, there's no gun, except for the cop's gun.
True, but he was running away. This guy was no threat to the cop because he was running away. His back was turned. The cop stopped. He squared up. He initiated that. He wasn't still chasing after him. And that's why I think this is a very compelling case for prosecutors and the jury.
Kimberly, let me throw the gun into the mix here, and I think that's going to be one of the contested issues in this case. Was he holding the gun? Was he a danger to the police officer? How about a danger to the community? How important is that piece of evidence, and will that make the difference, or is it simply the fact of running away, regardless of whether he has a gun or doesn't have a gun?
I think first it is about the fact that he was running away from the officer. Like he was de-escalating the situation when the officer was not. And additionally, it's not illegal to have a gun. I can have a gun. It's not illegal.
Vinny.
Right, but it depends what's in the officer's mind at the time. It depends what was in the officer's mind at the time and whether it was reasonable based on what he knew. We don't know. We had a case here last year, Chip Olson, who was acquitted of all the murder counts, convicted of manslaughter, and there was a naked jogger running at the police officer. Part of the defense was what Chip was told at the time while he's driving over to the complex, and he relied on other people, and he understood to be a dangerous situation. He may have overreacted, but based on what he was being told by dispatch, part of the reason he was acquitted of murder.
Vinny, if I could pop in here for a second, I do think that an interesting subtext to this is that the police officer is going to be allowed to introduce some evidence of the victim's past criminal record, even though the police officer didn't know of it when he chased him down and shot him in the back. I wonder why the judge is allowing that in, but that could be a lifeline to the police officer's defense, that he's going to be able to introduce the evidence of prior bad acts of the victim, even though the cop didn't even know about it when he engaged him.
Kimberly, do you expect this officer to testify?
Yeah, I mean, he has to. We have to know what he was thinking. We have to know that he was afraid, and why was he afraid? He's going to have to let us know why he was so scared that he would shoot a man that's running away in the back.
He may not testify, Vinny. Chip Olson didn't testify because they had a statement to GBI that has grand jury testimony, that had a lot of other things, his immunity hearing. He may not have to.
Oh, he's absolutely going to testify if he has any chance of getting away with it.
All right, folks,
like
it's one that we are covering. We're on the eve of trial. The trial is set. They just need to find a courtroom and some jurors, and it'll happen. We're tracking it right here on Court TV. When we come back, new developments, a new arrest in the case of the stepmother, Letitia Stout, out in Colorado, accused of murdering little 11-year-old Gannon Stout. Well, now there's a new charge in the case involving some leaked documents. We've got the latest next. Letitia Stout has been accused of the murder of her stepson, 11-year-old Gannon Stout, and she is in jail and she has been charged with that case. There is a lot of evidence, but a lot of that evidence has not come to light, but some did when the arrest warrant was unsealed by the judge. But the reason the judge unsealed the arrest warrant is because someone allegedly leaked that arrest warrant. So, the Deputy District Attorney Michael Allen in the case made an announcement the other day about new charges against the person responsible for leaking the document before it was unsealed. Let's take a listen.
I just wanted to share some news with everybody today. The affidavit in the Gannon Stout case was sealed for a reason. The reasons included to protect the integrity of the investigation as it contained information known only to law enforcement and the persons involved in that investigation. But it was also sealed to respect Gannon's parents and relatives. It was our plan, with the court's full cooperation, to present the affidavit to them and answer their questions before they saw it online or in the media. That is a courtesy I'm sure everyone can understand. Unfortunately, Gannon's parents were deprived of that opportunity because someone allegedly decided to leak the affidavit to the public while it was still under a court seal, meaning it was protected. I understand and respect the public's right to know, and I respect the press and the important job that they do. but sometimes information has to be kept close and protected for a reason. And this case and situation might help people understand why. And I really do hope that today serves as a cautionary tale for everybody going forward. The charges in the new case are like all other charges. People are presumed innocent until proven guilty. They're merely allegations. And that proceeding will be handled by the 17th Judicial District Attorney's Office. Dave Young is a district attorney in Adams County, and I've been in contact with him prior to the summons being issued this morning.
Has a leaked affidavit in Colorado ever resulted in a case being tossed out or dismissed?
I can't think of anything off the top of my head, any cases that have been dismissed as a result of a leaked affidavit. For something like that to occur, where a case would be dismissed, it would have to be because of some sort of inappropriate behavior by somebody on the prosecution side of a case, and I don't know of anything like that. And I think this shows also, too, that the prosecution, the court system, and the defense team are really trying to have some integrity with the way this case is proceeding, and it wasn't leaked by anybody associated with this case, and I think that's a good thing.
Last question for me. Is the leaked affidavit forcing this case to go to a different county, change of venue due to publicity?
Every big case that we get, and I'm speaking generally here, every big case that we get, it's pretty common for defense to file a motion to change a venue. I'm sure that will happen in this case, and then the court will make a decision. Obviously, we want the people of El Paso County and Teller County to be able to hear this case, the facts, and be the deciders on a jury. And so we'll fight that or oppose any motion to change venue. But that hasn't happened yet. We're not at that stage.
And like you said, you wanted to be able, in that week time frame before it's released out to the public, you want to be able to speak to, Gannon's parents about this, to tell them, kind of what's going on, and have some integrity in this case.
Right.
But with this being released, just a week early, do you think that this is going to have a big impact on appearances and everything moving forward? You touched a little bit about possibly the defense filing something to change a venue. But besides that, do you think that this, just being released a week early is going to have a big impact on the case at all?
It's hard for me to predict anything like that. I can't see how that would impact the case really at all. It was going to be released at any point by the judge 1 week later. It's just the fact that it was leaked while it was still under seal. Somebody violated that order, the court order, and also deprived the parents, Landon and Al, of the right and respect that they deserve as victims in this case to really have a chance to see it before they are just confronted with it on the media or in online. So.
And we know that, this is a huge case. There's Facebook groups with tens of thousands of people.
Right.
But it's something like this, an arrest affidavit, ever been kind of like leaked before in a case this large? Or is this very unheard of for here in Colorado?
It's happened. I can't name off a bunch of different case names where it's happened, but certainly leaks happen in cases. Unfortunately, it's not something that we want to see happen. And I get it. I understand a case like this. Why the public and people online would want to have access to information. Everybody wants to know what happened, and I can understand that part of it. But we also have to protect the integrity of the case. That's my biggest concern.
And then last question for me is just what we were talking about before. For Letitia Stout, when is her next court appearance going to be, and when is that going to start picking back up?
Yeah, so Letitia Stout's case is proceeding despite the slowdown with COVID-19. We have a preliminary hearing and a proof evident presumption great, which means it's really just a bond hearing. We're set for June 5th and June 8th. So coming up fairly soon, about a month away from today, actually, we'll be starting. So we're proceeding and getting prepared for that hearing. And that'll be the first opportunity for us to present evidence to the judge to show that we've got enough evidence to go toward trial.
All right, so what does this really mean? Let's bring back in our think tank, and again, we got the heavy hitters in tonight. Dave Ehrenberg, you are the state attorney, Palm Beach County down in Florida. How much of a problem is this, and how much of an issue is this day to day in cases that you're handling down there?
It's rare for something like this to happen. And unless this was caused by the prosecution, the court's not going to be throwing this out. It's not going to have a major impact on the case. It will give the defense counsel better argument to try to get the venue changed, but I still don't think that's going to work because, after all, this leak only released these documents 1 week before they were going to be released anyways. I'm just curious at the motive for this assistant city attorney to release this. It looks like she didn't get paid for it. Now she faces up to a year in jail. And by the way, that attorney, the assistant DA who spoke, he did a great job in setting it forth. That guy's got a future either in politics or maybe as a talking head on your show one day, Vinny.
I will definitely try to track him down after this trial is over for sure, because they don't speak that much out in Colorado. I know Florida, much more transparent in the judicial access of cameras.
We call it
and documents,
sunshine.
et cetera.
We're the sunshine state.
Exactly. It's the best disinfectant. Kimberly Bandeau, looking at what happened here, should anyone be concerned? Do you think it has any impact on the murder case against Letitia Stout, which is everyone's top priority?
I don't think that it has any effect on it. As he just stated, it was going to be released anyway. So I don't think that it's going to compromise anything. You don't need a venue change. I think they can go forth as planned.
Lawrence Zimmerman, the venue change. I was going to talk about that. You know, that's the one thing that comes up in every high-profile case. And you've had high-profile cases, and you've helped me cover some high-profile cases. Do you think the I'm not going to call it whining, but you know, and it's usually the defense, right? 9 times out of 10, it's the defense. We need a new venue. I mean, you guys really don't need a new venue. Can't we always find 12 people anywhere?
It depends. I mean, listen, I mean, if it's super high profile, I mean, and people have preconceived notions about the case and they can't be impartial, and you go through that jury, I mean, that happened in the case we covered, and that was part of. You know, you have to change venue. It may not help you, but I mean, that's the law. If there's pretrial publicity, but it's very rare for cases to have a change of venue. It has to be real pretrial publicity. You can't get a fair and impartial jury impaneled. Just because there's a leak of information, I'm not really sure the prejudice is here. It helps the defense more than it helps the prosecution, honestly. The defense could now throw daggers and say, look at them. They play fast and loose, and some city attorney did this purposefully. And who knows what else? Who else knows what else they could try to come up with? I'm sure Dave would have a great response.
Yeah. This is something we all agree with.
Here's the little secret. Yeah, but here's the secret that no one really realizes. And we only cover high-profile cases here on CourtTV, right? And inevitably, when you have that super high-profile case and you have so many people that have formed their opinions based upon evidence that they've seen, right? And it's obvious. None of those people end up on the jury. So the defense in high-profile cases ends up with better jurors. The publicity, the negative publicity, the exposure of all the evidence in front of prospective jurors inevitably helps the defense, Dave. Do you concur with me on that? Because I've seen it in action.
Vinny, I totally agree. And I've had some really high-profile cases, and we were still able to get a jury. You'd be surprised, you understand this, and Lawrence and Kimberly know this, that you could have a sensational crime case, and yet there are people who have never heard of it, or they just weren't paying attention. So I'm not surprised that you can get a 12-member jury in any jurisdiction, in any high-profile case.
Absolutely. Not everybody, unfortunately, watches CourtTV day in and day out like you all do that are watching now. When we come back, folks, the 13th juror speaks. It's the really huge story of the day. The video is everywhere now, and we get your take on it. I'm comparing it personally. I say it's the Trayvon Martin case with a videotape. Your take when we return.
Hello. 911, what's the address of your emergency?
I'm out here at Satilla Shores. There's a black male running down the street.
Satilla, where at Satilla Shores?
I don't know what street we're on. Stop right there! Is it? Stop! Travis!
Sir, hello, sir.
It's the story that I'm calling the Trayvon Martin case. It's the Trayvon Martin case, but with a video. That's what we're talking about. We're talking about Ahmaud Arbery down in Georgia, jogging through the neighborhood and gets shot and killed. A couple differences. One, there's more than one citizen, and none of these people are police officers anymore. You have more than one citizen with a gun, And this one, as I said, is on video. All right, a lot of people talking about it on Facebook. Put a post up there. Now we got your reaction. We begin with our comment of the day coming from Pauletta, who writes, in my opinion, racial profiling and the murder of unarmed men are a shameful commonplace in our society. As long as the George Zimmermans of the world continue to escape accountability for their actions, nothing will ever change. Rest easy, young man. My thought and prayers go out to this family and to our society as a whole. Kimberly Bandeau, go to you on this one. Do you think the verdict in the Trayvon Martin case has impacted the way people act?
Yeah, I do. I think it gave them a sense of confidence that you can create a narrative that you were afraid or you saw someone, the neighborhood watch person, and that you can protect your neighborhood and community and effectuate a citizen's arrest. And I think that empowered those people who already wanted to do it anyway, and to think that, hey, if he said it and you can come up with some kind of defense, then, hey, I'm going to get away with it as well.
Nikki writing tonight, this was absolutely disgusting. I felt like I was watching something from the 1950s as opposed to 2020. I really hope this young man and his family sees justice, but I am not hopeful that they will. I am utterly enraged and heartbroken by what I saw in that video. Lawrence Zimmerman, you practice in Georgia. Glynn County is where this case is. What do you think a Glynn County grand jury does? What do you think a jury would ultimately do if it ever gets there?
I mean, you're asking me a very difficult question. I would assume any normal good grand jury would indict this case. There's not much to bring an indictment. The trial's a lot harder, obviously. I don't know all the facts. I mean, the video looks pretty bad from the defense perspective. I don't know how it fits under justification. I mean, it looks and sounds like malice murder. Maybe they end up with a manslaughter conviction, which is still 20 years max per count. It's just sick all around. No matter, I can't think of a justification anyway. I know I'm a criminal defense lawyer, and I always try to find some good angle, but it just, again, I'll give the presumption of innocence. But your person who wrote that on social media is right. My 11-year-old daughter's watching this tonight, and it's sickening that in 2020 we have to see something like this. It's sickening to see it in 1950 or whatever year, but in 2020 we still
absolutely
this. Yeah.
Shane is writing tonight, and this is I think geared right towards me. Comparing this to Zimmerman is outrageously ignorant. Before continuing to spew such misinformation, please watch the entire testimony of Rachel Gentile. I watched it. I also interviewed her for an hour after the trial. Zimmerman was profiling and overzealous, but he did not initiate the physical confrontation. At most, Zimmerman was guilty of manslaughter. These fools committed first-degree murder. All right, Shane, first, the reason we don't know, Rachel Gentile was an ear witness in that case. There was no videotape of what happened in the George Zimmerman case. So we don't know exactly how things initiated. Dave Arenberg, if someone confronts you with a gun, are you entitled to defend yourself?
Yes, under Florida's stand your ground law, which is common with a lot of states, you're allowed to meet force with force. But you have the jogger in this case who didn't have anything on him. He was confronted by three guys.
I'm flipping the script, Dave. Dave, I'm flipping the script. I'm talking about did Trayvon Martin have a right to defend himself when George Zimmerman confronted him with a gun? Because everyone always points to Trayvon Martin was beating up George Zimmerman, but was Trayvon Martin defending himself from George Zimmerman, who confronted him with a gun? We don't know because there was no video.
Well, also, keep in mind this, Vinny. A key fact in the Zimmerman case, which the writer ignored, is the fact that the 911 operator told George Zimmerman to stay back and do not follow Trayvon Martin. Yet he did. And so in that sense, he initiated the conflict. Even though Trayvon Martin, yes, he got his blows in, and it was a mutual scrap. But Trayvon Martin, yes, would have been justified under stand your ground. He's got this guy following him with a gun who was told by the 911 operator to leave him be. So yes, I thought that justice was not done in that case in my state. And I think ultimately, though, we'll see George Zimmerman again, as we have multiple times, in various prosecutors' offices.
Always great to have you all with us. Dave Arenberg, State Attorney down Palm Beach County, Kimberly Bandeau, Lawrence Zimmerman, two incredible defense attorneys. Thank you so much. Stay safe out there. That'll do it for tonight, folks. 8 to 11 p.m. live every night here on CourtTV, bringing you inside the world of crime and justice. Have a great night. And from a distance, don't forget to hug the kids.